Welcome everyone. Thank you for joining us today. I will give everyone a few more minutes before we get started. Okay, so welcome again everyone. My name is Agnes Abelite. I have been working for the company's office for about 9 years now, and in the last year I have predominantly focusing on the implementation of the Insolvency Practitioner Regime and its impacts on the registers that we administer here at the company's office. So just a little housekeeping before we get started. To avoid noise and disruption, please note that all attendees will be muted throughout the webinar. The webinar support team will not be monitoring the chat functionality during the webinar. So if you do have any problems hearing us or any other technical questions, please make us aware by reporting your issue in the Q&A messaging function, and our lovely team here will be able to assist. Questions and answers. If you have any other questions or comments, please type them into the Q&A box in your Zoom control panel throughout the webinar. I will give everyone a second to find the control panel now. Normally, if you hover over your mouse over the Zoom screen, you will see it at the bottom of your screen. So I hope you've all found the Q&A function, and just to know that the questions will be answered after each speaker has finished their presentation, and we will have 2 speakers today. So please note we are approximately, how many are we? We are 47 participants today, and we will try to answer as many questions as we can. I'm sure we will be able to answer all of them because we do have hour and a half to cover our presentations as well as the questions and answers. So the schedule today. My colleague Kalantha Juneja will start the presentation by introducing you to regime, its purpose, associated legislation, and she will also cover the transitional period. Then we will have 10 minutes for Q&A. In the second half of the webinar, I will demonstrate the new Insolvency Practitioners Register, serious problem online form, and also I will outline the key changes to the company's register, and will show you the new summary report online form. If for some reason you are disconnected throughout this time, please go back to your confirmation email and the link to the Zoom and rejoin us. Maybe try a different browser this time. Please know that you are free to connect and disconnect as you please. Since attendees are muted, no one will be able to hear when you arrive or when you leave. And if you can only stay for a portion of this webinar and want to watch the rest later, or your colleague was not able to join us today, that is not a problem. The webinar presentation will be recorded and posted online on the Insolvency Practitioner Register website early next week. And now I will pass you on to my colleague, Kalantha.
Thank you, Agnes. So just a bit about me before I take you through some of the content today. So I graduated with an LLB and BA in 2010 from Canterbury University. My litigation career began at Keegan Alexander, where I worked on a wide range of civil and commercial matters. Prior to joining the company's office legal team, I worked at Meredith Connell in the Insolvency and Recoveries team, acting for the official assignee. And I also appeared regularly at the district and high courts as a Crown prosecutor in criminal matters. So a typical day at the company's office involves me providing legal advice to the registrar of companies and incorporated societies, and I've advised on the Insolvency Practitioners Regulation Act 2019 and its regulations. More recently, I've been revising some of the legislation regarding conducting meetings and things like that under the COVID-19 restrictions. So let's have a look at the first slide before the regime. So as we all know, insolvency practitioners played a fundamental role in corporate insolvency procedure. We know they're placed in a position of trust and responsibility to ensure that the interests of creditors and other parties concerned are protected. As you all know, the majority of IPs in New Zealand are from the accounting and legal profession. Before the Act, there were no statutory requirements that an IP must satisfy in order to be appointed. They could be appointed as long as they were not disqualified under the Companies Act or the Receiverships Act. As you all know, the provisions in these acts apply to liquidators, just the Companies Act, and administrators, whereas the rules in the Receiverships Act only apply to receivers. So those acts sets out classes of individuals who were disqualified from acting as insolvency practitioners, such as an undischarged bankrupt or a person under the age of 18 years old. However, and this is where the real issues arose, anyone else could be appointed as a liquidator, administrator, or receiver, even if they did not have the adequate skills or knowledge required to undertake an insolvency engagement. Some of these individuals are what I like to call rogue or cowboy liquidators, and I'm sure we've all read about some of these individuals in the media or had the unfortunate experience of dealing with them. The Law Commission, in its 2001 study paper entitled Insolvency Law Reform Promoting Trust and Confidence, recommended that the regulatory regime should minimise the concerns of rogue liquidators. Unfortunately, nothing happened for a number of years after that paper until about 2004, when the NZ Ministry of Economic Development, as it was known then, released a discussion paper concerning IP regulation. Again, nothing eventuated from this until about April 2010, when the Insolvency Practitioners Bill was introduced. It took about 10 years for this bill to really gain any momentum. The explanatory note to the bill noted that there were a number of practitioners consistently underperforming. This bill introduced a negative licensing regime, that would give the registrar the power to restrict or prohibit individuals from providing insolvency services. It also sought to introduce a number of new disqualifying requirements. For example, someone who has been convicted of a crime involving dishonesty would not be able to be appointed, nor would someone who has been expelled from the Law Society. This bill was then referred to the Commerce Select Committee in August 2010. In 2011, the committee recommended that the bill be passed with a number of significant changes. Importantly, this included abandoning the proposed negative licensing regime in favour of a registration system for IPs. The committee was of the view that the proposed system would not address the problems and risks associated with practitioners who are dishonest or lack independence. The committee further noted that it would be preferable to prevent such practitioners from undertaking insolvency duties before the damage had been done. Some of the insolvency commentators were of the view that the committee favoured an approach that was like a fence at the top of a cliff as opposed to an ambulance at the bottom of the cliff that was suggested in the bill. Because the hurdles to enter the profession were incredibly low, this exposed creditors to rogue practitioners. The existing barriers did not deter the appointment of a one-off debtor-friendly practitioner who did not care if they are later prohibited from providing services because the practitioner did not intend to be appointed again. This meant that the regulation of practitioners and ultimately the protection of creditors was dependent on a handful of brave creditors pursuing these rogue practitioners through the courts. But even then, it was too late because the damage had already been done. Claims against liquidators is also a very technical process and a lengthy and costly court process, as you may know with the procedures in the Companies Act legislation. Plus, it was not worthwhile because in some cases there were little or no assets left. The purpose of the registration system was really to allow the public to access information about IPs and also for the registrar to collect information from IPs to regulate them more effectively. In 2015, the Minister of Commerce and Consumer Affairs announced the formation of the Insolvency Regulation Working Group to evaluate insolvency laws, including the regulation of IPs. In July 2016, the working group released the first of two reports which provided advice on the regime that regulates IPs. The report undoubtedly confirmed that the status quo was highly unsatisfactory. They identified two significant reasons why a number of IPs fell short of the standard that the public were entitled to expect. Firstly, it is too easy for an individual to become an IP. Secondly, there was a real lack of accountability for poor behaviour. The likelihood of a creditor or other party challenging the conduct of an IP in court are slender, as I mentioned before, due to significant legal costs. And fast forward to 2019, we have the Act being passed and the regime which was enforced from the 1st of September 2020. Let's have a look at the purpose of the regime, which is your next slide. So the purpose is really a focus on accountability of these insolvency practitioners. It's to establish a robust regime that will include rigorous competence, honesty and integrity criteria for practitioners to obtain and hold on to that license. It raises the standards of insolvency practitioners over a period of time. And some of you may be familiar with the insolvency regulation laws in the UK and also our neighbouring country, Australia. And they have very robust procedures in place compared to our previous one. So it's great now to see that New Zealand has followed suit. Let's have a look at the legislative changes. Now this will be your next slide. So the new regulatory regime introduced by the Act came into force on the 1st of September 2020. The Act introduces a co-regulatory scheme under which accredited bodies will be responsible for carrying out the frontline regulation of insolvency practitioners, including regulating the entry and ongoing competence, investigating complaints, and taking disciplinary action where appropriate. And the registrar of companies will be responsible for oversight of the accredited bodies. Oversight includes accreditation of bodies, ongoing monitoring and reporting, and corrective action relating to the quality and effectiveness of accredited bodies, the regulatory systems and their processes. The registrar will also maintain a register of insolvency practitioners, which will be publicly searchable, and Agnes will take you through this register later on during this presentation. So the accredited bodies, again, to remind you, are the frontline regulators, whereas the registrar is just a watchdog, if you like. And ZECA is an accredited body under the Act, and they have statutory responsibilities under the New Zealand Institute of Chartered Accountants Act to regulate the practice of its members. The new Act amends the Companies Act 1993 and the Receiverships Act 1993 to provide that the content of the reports which practitioners are required to prepare during an insolvency need to be prescribed in the regulations. These reports comprise an initial report soon after the practitioner is appointed, reports every 6 months during the course of the insolvency engagement, and a final report after the engagement and an insolvency process has been concluded. So other features of this regime include the registrar has a discretion to grant accreditation to individuals or organisations that are responsible for issuing these licences. Accredited bodies must issue a licence where the applicant meets the minimum criteria. Licensed practitioners must apply for a new licence at least every 5 years and must satisfy ongoing competence requirements. An insolvency practitioner without a licence will still be able to administer solvent liquidations, provided that they are a lawyer, an accountant, or a member of a recognised professional body. And the scope for licensing overseas practitioners will be limited to Australian insolvency practitioners initially, although the registrar will have the power to extend it to other jurisdictions with comparable insolvency regimes. IPs registered in Australia will be able to accept an insolvency engagement in New Zealand without being licensed here, provided that they apply for a license within 10 working days of an appointment. A new change to this that this regime brings about is the filing of a summary report for an IP. So an IP will need to file a summary report as soon as practicable after completing his or her duties. For example, this is at the time or after a liquidator files a first and final report, a receiver files a final report and notice of the end of receivership, or an administrator files an end of voluntary administration or a failure of notice for a company arrangement. The summary report will be filed by all 3 IP practitioner types, as I've just mentioned. The summary report will contain all this information prescribed in the regulations, and Agnes will show you how that report is to be filed. The purpose of this summary report is to improve reporting by IPs to enhance the transparency and accountability so that creditors will not need to refer back to previous reports and to do their own calculations. So it's really a one-stop shop to have a look at all the information and all these calculations that's gone on during the insolvency. And this information in turn will also help the registrar to measure the success of the new regime with the with the preparation of oversight plan and reporting. A liquidator must prepare and file a summary report relating to the liquidation if the liquidation is commenced on or after the 1st of September 2020. When liquidation proceedings are completed, the liquidator must give public notice of their intention to remove the company from the company's register, file a copy of their report and a copy of the public notice to remove the company from the register, and file a summary report. And I've gone through sort of focused on the requirements for liquidators because generally most of the IPs are liquidators or will be liquidators. So the prescribed information for a liquidator summary report is set out in Clause 9 of the company's Reporting by Insolvency Practitioners Regulations 2020. The summary report is referred to in Section 257, subsection 1C of the Companies Act 1993. And in respect of a company liquidation, it must contain this criteria. And for example, I'll just name a few of the new items. For example, the liquidator will need to mention the registration number of the liquidator, including any liquidator who left office during the liquidation and their contact details. For an insolvent liquidation, the following information relating to creditors of a company: a summary of any amount paid to each class of creditor, including the total amount paid and the rate of payment, cents per dollar. And for a solvent liquidation, a statement confirming that every creditor has been paid in full. So let's have a look at the transitional period. This is a little bit complex. So the Act introduces a transitional period, and the transitional provisions allow individuals to complete insolvency engagements accepted prior to the 1st of September 2020, but they must be completed by the end of the 1st of September 2021. However, a person cannot undertake any new insolvency engagements from the 1st of September 2020 unless they qualify for a transitional license. Practitioners who are accredited at the time of the commencement will automatically be granted a 4-month transition in which to apply for a license, with an additional approximately 8 months for license applications to be processed. If a practitioner does not apply for a license within this window, then the practitioner's license will expire. The transitional provisions will allow for a practitioner to continue practicing for a further 8 months while an accredited body determines that practitioner's application. In relation to in-flight liquidations or insolvency, existing insolvency engagements, a liquidator who is not licensed will have a year to complete the liquidation once the licensing regime is in force. If the transitional period applies, the person does not need to be a licensed insolvency practitioner. So really the purpose of this transitional period is intended to allow liquidators that do not wish to become licensed to complete or transfer existing liquidation engagements. People relying on this transitional period must complete all liquidation engagements, or resign as a liquidator, or transfer liquidation engagements to a licensed insolvency practitioner, or obtain a license to act as an insolvency practitioner. In terms of the application process and refusing a license, It's important for you to know that the registrar has no role in licensing decisions. They cannot overrule an accredited body's decision to grant or refuse an insolvency practitioner's license. If an applicant wishes to challenge a licensing decision by an accredited body, the Act provides that they must appeal to the High Court. So in terms of solvent liquidations, as I've mentioned before, qualified accountants and lawyers will still be able to accept appointments as liquidators of solvent companies. If a liquidator is not a licensed insolvency practitioner and it becomes apparent that the liquidation is an insolvent liquidation, the liquidator will need to resign without delay and appoint a successor who is a licensed insolvency practitioner. Directors will need to provide a declaration that the company is a solvent company and will be able to have their debts paid within 12 months following an appointment of a liquidator. And they must have reasonable grounds for making that declaration, otherwise it's an offence under the Act and they may be liable for a fine of up to $10,000. So other changes that may be of interest to you, creditors' rights have been strengthened under the legislation. A company will no longer be able to appoint its own liquidator following service of liquidation proceedings. So once liquidation proceedings have been served, the creditor's consent will now be required if the shareholders or the board wish to appoint a liquidator to the company. Liquidators and administrators will be required to prepare an interest statement disclosing any relationships that could reasonably be perceived as creating a conflict of interest. They will also need to update these statements every 6 months to capture any new information. So the Act also introduces what's termed as reporting serious problems. And this is a new obligation and a very important one on practitioners. It really expands the protection for practitioners by providing for a broader range of reports to a broader range of regulators. Insolvency practitioners will be required to disclose serious problems to the registrar, the Reserve Bank of New Zealand in respect of a licensed insurer, the police, or anyone who is really responsible for investigating the matter. A serious problem, as it's termed in by the Act, will deem to be arisen where, for example, the company or a past or present director, officer or shareholder of the company has committed an offence. A person involved with the company has misappropriated company assets or is guilty of negligence or a breach of duty in relation to the company. A past or present director has breached a director's duty in a material respect, and or the company has been managed in a way that has materially contributed to the company's insolvency. And Agnes will take you through and show you where this form can be found. So that brings me to the end of my content. Hopefully that's been helpful. So we've got about 10 minutes for some questions before I hand you over to Agnes to show you the exciting part of how the register works.
So feel free to add any questions that you have in that QA box that you can find at the bottom of the screen. If you hover over your mouse, you'll see the control panel there. Or possibly Kalantha's presentation was so self-explanatory.
Don't be shy, I can't see who's asking the question.
There's no questions to ask.
And if you have a burning question that you'd like us to answer later on, or your colleague that couldn't watch it today and is watching it at a later time, we do have an email address at the end of the presentation on the PowerPoint that you're welcome to submit your question there. The questions come through.
So the question is, I thought shareholders still had 10 working days after the liquidation application to appoint their own liquidator.
Sorry, I did cover that question off, and yes, that is right.
Okay, so that's still the case. And then we've got another question. What action will the registrar take against appointments that continue to be late advertised but are predated 31st of August 2020? In some cases, the Register of Companies has not been updated.
Yes, so this is in relation to, we've actually had a couple of these for appointments made on the 31st of August. And we do, we have to deal with those appointments manually.
Yeah, I think the question is more pre-dated 31st of August, and if we're going to take any action if the appointments are advertised late. So I know that they've got 10 working days to file their appointment with us, and the new regime will change to that the appointment has to be filed with us by the end of the next working day. So I guess we can look into.
So I will have to look into that question. I mean, there will be a couple of teething issues with, you know, what the registrar, how the registrar will deal with these new changes in terms of late advertisements and things like that, particularly because of COVID-19 too.
Then we've got another question. Will New Zealand practitioner be able to practice in Australia? Do you know the answer, Clint?
No, sorry, not off the top of my head, Agnes, but I will be able to look in that question at that question for you and get back to you.
Perhaps what we could do is gather these questions, and along with the webinar recording and the PowerPoint, we will post the answers on the Insolvency Practitioner website early next week, just so that we close that loop properly.
Sorry, and just in relation to the first question that was asked in terms of the shareholder appointments of liquidators, you need the creditor's consent to do that for 10 working days. So you'll still be able to do that. Just to clarify that.
Okay. So I guess I'll carry on. If you do have more questions, please feel free to post these, and if we can, we'll answer. If no, we'll prepare the answers after this presentation. Right, so I will show you the new register, and I'm sure those of you who are licensed practitioners have already been online and have had a look at your details and have had a look at the registration number. This will be your unique ID. So I'm just going to stop sharing the PowerPoint, and hopefully, if all works well, I'll show you the new register and how to find it. So if you go to the companiesoffice.gov.nz, this is our parent website where you can find, so we've got 4 Tier 1 registers at the top of the page. Our smaller registers, 15 of them, can be found here. So Insolvency Practitioners is right in the middle here. We've had this website live for about a half year already, and this is where we posted our news and updates about the regime, the consultation period. There was also a delay due to COVID. The original commencement date was 17th of June, so we delayed it to 1st of September. So we posted all these updates online here in our news and updates section. There's some very, very useful content to read, and the register itself is here. So just show you the front page of the register. So this is the search page of the register. So you can search by practitioner's name, firm name, or the firm's NZBN, or the registration number of the practitioner. And you can also filter by the home jurisdiction. At the moment, all the practitioners on the register are based in New Zealand. You can filter it by the location of the business address of the practitioner. And at the moment, the only the body who is issuing licenses, the accredited body is Insolvency. And so we've also got returns who have been recognised by the registrar as a recognised professional body, and returns they're working closely with NZICA, and their members are being reviewed by NZICA, and NZICA is ultimately responsible for issuing their licenses as well. So here you will find, I believe it's 118 insolvency practitioners that have a transitional license, and you can view their details if you just click on the right, show details. So typically on the left, we will show the details of the insolvency practitioner, and on the right will be the details of the license, all the different dates, when it was issued, when it will expire, and the conditions of the license. And you can view the condition if you click on this PDF here. Over time, the history, all the annual confirmations filed, or any other details will be noted in the history and notices section over here. And just to let you know that the way the information flows to us is that the insolvency practitioner applies for a license to an accredited body. They review the application. If they issue the license, they pass on the details to us, and then we register this practitioner on the register. And if the details subsequently change, you also go to your accredited body, and they will inform us of these details that have changed, and we will update those on the register. So, so please don't come to us, as the legislation requires you to go through your accredited body. Same goes with the annual confirmation. So annually, it's going to be in June. The accredited body will be in touch and ask you to file the annual confirmation along with a fee. And then this information will be passed on to the registrar, and we will update the register to include a date when the annual confirmation has been filed. So Kalanta touched on the transitional period. So at the moment you can see all these practitioners and they do have a transitional license. You will have until 5th of January 2021 to apply for a full license. And then the accredited body will have up to 8 months to review the license and issue the full or reject the application. So that's an important date for you all to do this before Christmas. because 5th of January is the first working day in the new year. So do not miss that date. And I believe in Zika, they have already, I'm pretty sure they have, I've seen the online application form, so you can go to their website and find out information about the process and find the application that you need to complete for the full license. Right, so that's all about the Insolvency Practitioner Register. So essentially the purpose of the register is for the members of public to check a status of an insolvency practitioner and its suitability, their suitability to perform insolvency duties, and to contact one if they wish to engage their services. Okay, so Kalentha touched on the obligations of an insolvency practitioner, and one of them is a new obligation. It is to report a serious problem. Now, to find this form, we created an online form just to make it a bit easier for you to do that. And to find it, if you go to the main page of the Insolvency Practitioners Register, and if you go to Practitioner Obligations, then at the very bottom of this page, you can read more about the reporting of a serious problem. And then here you will see a button that you click on and it takes you to the online form. So I've pre-filled one already so that I can show you all the different tabs. So it's under section 60 of the Insolvency Practitioners Regulation Act that this form is required. And we divide it into 4 tabs. So in the first one, there's an overview of the problem. So it's the insolvency practitioner details, with the registration number. The registration number you can find on the register. Then the body corporate details. So if it's a company, it's an entity type that you can select from. You'll provide the name and the number and the NZBN. And you can report of about more than one body corporate. If you do have a list of 10 or 20, feel free to add a file that lists all of the affected entities. And here you tick which serious problem you are reporting on. And then in the next couple of tabs, you will be providing the details of this problem. So if you are reporting a criminal offending, you will need to provide the criminal offender name, their role within the body corporate, and then so on. So if each of the type of the problem will have the details here that you will need to provide. And in the last tab, so you can provide more details about the nature of the criminal offending. And also, this part is really important. You need to tell the registrar who you have been or who you will report this problem to. So the options there are Reserve Bank of New Zealand, New Zealand Police, body responsible for investigating or prosecuting the offence, or perhaps none of the above. Okay, and then you submit your report. It will go directly to our integrity team, who will investigate the problem and will engage with one of these third parties that you've identified. So that is the serious problem form. Okay, so I shall go back to the PowerPoint screen and we'll talk about the key changes to the company's register. Right, so here on the screen you can see the key changes listed. So you may or may not be aware that there is a new insolvency practitioner levy which is $1 that has been introduced to company incorporations and annual returns. And this levy commenced from 1st of September. So any transactions from 1st of September, 1 minute past midnight, will have an additional $1 levy. And this is to cover the costs for the new register and the new regime. Then we made some amendments to the user account of the company's register. And essentially, we've added a new insolvency practitioner flag that helps us to identify the licensed insolvency practitioners, and also to add the details of their license, status and type, and also the registration number. And the reason why we've done this is because we do want to restrict access to the company's register going forward. If at the moment, if before 1st of September, anyone with access to this insolvency online module, anyone within that organization account was able to put a company into liquidation, then from 1st of September, only those who are licensed practitioners will be able to be appointed. So, so that restriction is there in place already. And we do allow, of course, people who file on behalf of insolvency practitioners to still do the same practice as you currently do, but you will not be able to add a new appointee who is not licensed. So that's the key difference here. For those that are completing your pre-1st of September appointments, filing reports for those insolvency engagements, you will still be able to carry on without a license because of the transitional provisions that allow you to do that. So I'll show you in the next screen how your admin user of the organization account will be able to check if you do have the required settings to be appointed. Then just explain that we're going to apply these new eligibility validation rules when filing an appointment, filing a report, and also maintaining a company. And then in the insolvency dashboard, which is that online tool that you use to make new appointments and to file reports, we've also made some changes to the appointment screens. There's some new information that you will need to provide, and I'll show you that shortly. And also the new summary report tab. And this is applicable, as Kalintha mentioned, to liquidations, receiverships, and voluntary administrations. Also, there will be a new reminder to remind you that you need to file the summary report. And this will basically work as soon as you file your final report or equivalent. We will send you an email to all current appointees of that insolvency engagement, letting you know that now is the time for you to go online and file the summary report. Okay, so this is the new insolvency practitioner flag that I mentioned. So your organization account administrator is able to go online already now on the company's register. Once they log in, if they go to the organization details and then select the specific user who you would expect to see this flag present, so that would be an insolvency practitioner with a license, you'll be able to see, as you see on the screen, insolvency practitioner details. So their eligibility is licensed, type transitional license, it's active, and you would see the registration number. The reason why we added registration number here is purely for your own benefit. And this is when you will file the summary report. We will pre-populate this registration number for you, so you don't have to enter it every time you file the summary report. And important to note that obviously these details are private, so nobody else will be able to see it because these are captured in the user account. Okay. So the liquidator's appointment, there is a new field that we've added to the first screen of the liquidator appointment. And as we said, please provide the name of the person who made the appointment, and if the liquidator was appointed by the court, who applied to the court for the appointment. So it's very similar for the voluntary administration and receiverships appointment too. And at the bottom of the screen, you can see once the appointment is filed, where you will be able to see this new data supplied to us. So that will be all public. Same for administrators' appointment. Receivers' appointment, there's a bit more information that the Act requires. So if it is a new receivership, you will be providing description of the deed, agreement or instrument. Then also you're required to upload a copy of the notice that is sent to the grantor, and also information the same as for liquidator and administrator appointment, which is the appointed by. And so all of this information will be made publicly visible against the company record, where you see the receivership or liquidation details. All right, so now we're up to the summary report. On the screen here, you can see the new tab that we have added for this report. It's quite a bit of information that you need to provide, and the difference between this report and all the other reports that you file is that the other reports are PDF documents and you simply upload them. So it doesn't give the registrar any ability to do any statistical analysis, whereas the new summary report is an online form where you will key in the information, and it will allow us to aggregate the data and make the statistical analysis to understand, to report back to the public and on the health of the new regime. So I'm going to stop sharing the PowerPoint now and go to our test environment, and I'll show you how to file a summary report. So as you do, you log into the company's register. With your RealMe login. And then you're taken to your dashboard. So to get to your Insolvency Practitioner online module, you go to Manage Receiverships and Liquidations, same as you do now. Nothing's changed in terms of how you access your insolvency dashboard. So in here, as you know, you will see all the companies that you manage listed down here. And this is where you can also make a new appointment and see all the due reports. Or if you select an existing insolvency engagement, you can file a report. So for this particular insolvency engagement, I have filed a final report. Therefore, I can now see this File Summary Report tab. If you have not yet filed a final report, you will not see that tab there. So nice and easy. If it's there, you can file it. If it's not there, it's not due yet. So once you click on the File Summary Report, we did a bit of customer engagement before we designed the form and during. And the most common feedback was, just make it easy for us to do it. So we followed your feedback and we tried to make it as easy as possible where we could. And the way we did it is basically by adding that new tab within that insolvency engagement, we were able to pre-populate most of the details that are in relation to the insolvency engagement and the appointee from that notice of appointment. So as you can see, all the company details are there for you. If that particular company will have a business industry classification code already against that company, we will also show it here. If we do not show it here, you can search it by a keyword. There you go, and then you just select the big code there. You will need to provide the operating area. So this is nationally, internationally, or if it's domestic region, you'll need to select the region. So these are the appointee details that I mentioned before. This is all the information we will pre-populate, including that registration number of the practitioner. The start and end date. The end date is the date that the final report is filed. So if in doubt, there's some help text that will help you to understand what information is there already. The method of appointment is basically your section 241, 2, and that A, B, C, or D. If you select court, you also need to provide further information. Then you will select the reason for liquidation, so you can select more than one, all that apply. And then the key difference between the liquidator summary report is if it's a solvent or insolvent liquidation. So for a solvent liquidation, that's all it is basically. You just need to confirm that every creditor has been paid in full. Normally you would say yes. In the unlikely event, if you do say no, then you have a mandatory comment field here to provide. And then you enter your email address, which will be made public as it is a requirement of the Act. But we do have a sentence here to let you know about that. If you select an insolvent liquidation, which will be majority of cases, there is further information that you will need to provide. And that is, as Clint mentioned, creditor payments. There's also a summary of recoveries. I'm not going to go through all the detail now. If you are interested, refer to the clause 9 of the regulations. You will not see more information required in the form as in the clause 9. So everything that's there is in this form covered. And the liquidator fees, we've broken them down into the current and other liquidator firm. And the form will calculate the grand totals for you. So that's basically it for the insolvent liquidation. There's a very, very similar form for receivership and voluntary administration as well. It looks exactly the same, it works the same. Again, please go to the regulations to see the exact information that you will need to provide. And we will also publish the PowerPoint where there will be a screenshot available of all of this information. So you will be able to see it next week. Now, the summary report is only applicable to engagements that start after 1st of September. That's very important to note. You do not need to file the summary report for your existing engagements, so you will not see that tab. It will, as soon as you file final report, it will drop off your dashboard. But for all engagements post 1st of September, that engagement will not drop off until you file the summary report. And we will send you a reminder and the final reminder before we refer to the integrity team for further investigation. So that's the summary report. I believe I've covered all about it. Okay, so I'll stop sharing that and we'll go back to the PowerPoint. Okay, so this brings to the end of my presentation. And here on the screen, you can see the email address that Clint mentioned before. There's also some additional resources that you can read once we post this PowerPoint. And now let's have a look at the questions and answers. Do we have any more open questions? So yes, we do. Is the summary report an online form or a report we prepare and file as we do with all other reports? So as you saw, it is an online form. So that's hopefully to your advantage. It's also an online form that once filed, it will be made public against the company record, and you are able to download a print of it, so you can upload that report if you do need to file it in your as part of your process. Okay, so next question. We've discovered teething issues with the summary report. Certain values may be nil unknown, but the form does not appear to accept this. Right, so the way, so our advice is if the information is not applicable or it was not available, you leave blank, but there are certain fields that must be entered. So it will depend on what sort of detail it is, because some of the fields are mandatory, some are conditional, some are optional. So I will need to know a bit more detail in terms of which fields exactly you are referring to. With the summary report, is there a CSV option or something similar we can upload with all the detail on and rather than entering manually? No, we do not have a CSV option, and I've seen some early consultation papers where CSV was discussed, but the most feedback we had from practitioners was that they did not want to use to submit a CSV, and therefore we ended up with the online form. So not at this stage. If we do receive further feedback, and if that's sort of a better or more preferred way of submitting this report, we could consider that, but we don't have that at this stage. Okay. Do you have a blank summary report that we can download? So as I mentioned, with this PowerPoint, there will be a screenshot of that summary report. We could look into providing another form, like a PDF, that might be a bit more useful than a slide. So I'll look into that and see what other form we can provide, because I definitely see a benefit for you to have it in a blank form. Okay. It relates to required information. I assume this is possibly would be best to get in touch with us directly in terms of that question that you had with the teething issues. So if you could just send us an email to practitioners@companies.govt.nz, then we can look into that issue and get that sorted for you before you need to file that report. Calantha, would you be able to help with the question? I assume a practitioner can claim remuneration for investigating and reporting. Will a practitioner be required to investigate and report if there are no remaining assets to fund that remuneration? If so, to the same extent?
I'll have to look at that question for you and get back to you.
Right, okay. So it's one of those that we're going to add to our Q&A and publish next week. And there's one more question. Appointed by, what if appointed by all 10 shareholders? Are all names required? I believe so, yes.
Yeah, that's required by the regulations.
That's right, yes. So there is enough space for you to, not to add a novel, but to add quite a, I think it was 450 characters from memory. So that should allow you to add all 10 shareholder names. All right. So we still got, no, we don't. We're done. No, we do. We've got 25 minutes. So if you do have any more questions, Feel free to add those now. I think I'm told that there's one more question in the chat. Right, is there a new time frame in which companies already undergoing liquidation through the High Court appointed liquidator to complete the liquidation process? Oh, I see. So correct me if I'm wrong here, Kalanta, but any appointment made by a liquidator, regardless of its high court or not, if the appointment was made before the 1st of September 2020, then they will be able to complete this liquidation without a license by the end of 1st of September 2021. So that will be the time frame for unlicensed liquidators. Are there any rules that you're aware of for the time frames of these liquidations?
No, you get a year. It's the transitional period is a year to complete those in-flight liquidations. And if you can't have it completed, you have to transfer the engagement.
And if it's a licensed liquidator, is there a time frame? Okay.
A time frame for a year, or
a time frame to complete a liquidation?
No, because I mean, some of them can go on for years.
Okay. We'll double check that and we'll add it to the Q&A. How long after the end of liquidation do you have to complete the summary report? So the Act is very unhelpful in this sense. It says as soon as practicable.
And that adopts the wording of the Companies Act legislation in terms of filing some of those reports as well. So we do send out reminders, as Agnes spoke to you about earlier. But again, we'll see how it works and if you have any feedback on that as well.
Yeah, we have implemented 1 month's kind of the appropriate timing to file. So 1 month after the final report, we think, and we did ask a few practitioners and they said that would be plenty. So the final reminder will be sent to you after 1 month of filing the final report.
And it is just a summary of the information that's already been
provided in the previous
anyway.
report.
So
that's right. Yeah,
should be ample time.
So hopefully that answers your question. Okay, so just a couple more minutes to see if we have any more questions. And thank you. Look forward to more information on this in due course. You're welcome. And apologies we were not able to answer all of your questions today, but we will definitely look into them and we'll post the answers online next week. So I believe I'm going to close the webinar unless you wanted to add anything, Linda. Anything?
No, thanks, Agnes.
Okay. So we hope you found this presentation useful, but we do encourage you to seek your own advice, obviously, in terms of changes to the legislation and also your obligations as an insolvency practitioner. And on that note, I'll say thank you, Kalanta, and our webinar support team who are showing me that there are more questions. Is the interest register a separate form or is it included in the 6 monthly report? Apologies, I don't know the answer to this question, Kalanta. Kalantha's unmuting herself.
Hi, I think I'm unmuted. Yeah. Sorry about that. Do you mean the expanded interest statement? That's actually done as part of the, I believe, the appointment form. If I understand the question, and apologies if it needs to be clarified.
Maybe if you could paraphrase the question, and we'll look into that after the webinar. That would be helpful. Okay, we'll just wait a couple more minutes to see if we have a... Someone says, I think the interest register they are referring to is DIRRI.
I'll have to look into that, Agnes, and get back to them. And it might be helpful for us to actually post some of these questions after, as I mentioned, some people who might want to watch the webinar later on as well. Because chances are some people may be having the same queries as well. So it'd be good to have these answers up where everyone can see them.
Right. All righty. Okay. We'll close the webinar here, and yeah, thank you very much, Kalantha, for presenting the changes to legislation and the regime, its purpose, and a very interesting history. Our webinar support team, you can't see them, but they've been amazing. And obviously all of you, thank you so much for joining us today, and have a fabulous weekend. Thank you.
Thanks.